Professor Lupu, I wanted to give you an opportunity to respond to what you've heard, and also a question that your comments raised to me is the difficult analytical question of what does the Establishment Clause guard against that the Free Exercise Clause does not, and where is that line? But I wanted to give you an opportunity also to respond.
Well, excuse me, thank you. Let me say just a word about Michael's original remarks, and then come back to the question you asked. I was listening, very carefully, as I always do, to Michael, and he made this very interesting analogy between religious enterprise and economic enterprise, or communications enterprise, right? Comparing freedom of the press with other economic institutions and a church. And the analogies are provocative and interesting, but they'll only get you so far, won't they, Michael? Because we do know that, yes, we do not have a USBC, a broadcasting company owned domestically by the United States. We do have a Voice of America overseas. I don't think there's anything in the Constitution that would preclude the government from having a completely publicly funded television or radio or voice. It has websites over the internet. It communicates its own messages in lots of ways. There's also nothing in the Constitution that precludes the government from deciding to own and operate means of production, whether it's coal mines or other kinds of things that the government might decide it's in its interest to operate. So with respect to institutional religious enterprise, there is something constitutionally distinctive about institutional religious enterprise, where we have this commitment that the government just should not be competing, or set aside the issue of exclusive governmental religious enterprise, excluding others. But we have the sense the government should not be competing in a way that's different, I think, from these other kinds of enterprises. Now, with respect to the problem of the Establishment Clause generally and government symbols or messages and speech in particular, I agree with Michael entirely that the extremes will not work. All the attempts at formulating rules and standards to this date, whether it's endorsement or something else, have produced deeply divided courts and deeply unsatisfactory results. Although when he says the court has tried to not take sides in the culture war, I think that is true of Justice Breyer's difference splitting in the Ten Commandments cases. If you read Justice Scalia's dissenting opinion in McCreary County, I think you will see some justices who are trying to take sides in the culture war, because he says it's okay for the government to not only acknowledge the role of religious ideas in our history or in our culture. Right? We could separate those. Those are two interesting and important categories. Acknowledgement of the role of religious ideas in our history, in the framing and the beliefs of the founders, in our culture. That would include religious holidays and celebrations that have some mixed religious and secular aspects. Christmas, for some, an example. But he also says that government can engage not in proselytizing, but in veneration. I think he uses the word veneration of certain kinds of sacred objects or ideas. And that seems to me indeed to take a side in the culture war about the role of government with respect to religious values. Now, he also emphasizes the generic Judeo-Christian quality of the Ten Commandments, which is why a case that involved government sponsorship of a cross as a war memorial or otherwise, a case that's up there this term, but they just may not reach the straight-out merits of this question. I think it's a much more difficult and constitutionally complex question, because the claim to at least generic Judeo-Christian coverage with respect to the cross just won't work, as I think Justice Scalia found out in the oral argument rather quickly when he made a reference to a cross as a sort of a universally acceptable symbol as a war memorial. And the ACLU lawyer arguing in front of him reminded him that in Jewish cemeteries, veterans or not buried in Jewish cemeteries, you will not see crosses, right? That these are respected but sectarian symbols designed to mark the place of the dead. So I think you're right that drawing the line is very difficult. I think there's some places where we shouldn't draw it, where we might go too far, and that seems to me an example. Now, to try to answer Judge Kavanaugh's last question about what should be the full role of the Establishment Clause and what it adds, I think maybe I'm going to pass the mic to Professor Brownstein, unless you want to give me another 20 or 30 minutes, and I think you don't.
Yeah. Professor Brownstein, on your remarks, I had a thought too, which is one of the very difficult questions that courts are confronting now, and I know Judge McConnell had a case that certainly had this in the background, is when you have private speech on government property, we think about protecting the free speech, but then we're concerned once you protect the free speech, especially if it's permanent speech in the nature of a symbol or monument, that it becomes attributed to the government and then triggers an Establishment Clause problem. Do you want to comment on that problem, which I know is the courts are struggling with, are going to really continue to struggle with, and also what else you heard?
Well, I think that question really piggybacks on what Chip said. The way I would characterize the issue of displays, whether you're talking about clear government speech or government sponsorship of speech, where they accept a monument that was created by private groups and have donated it to the government for placement on government property, is we're never going to solve this problem with a formula, but we can identify the criteria or values that are at issue in trying to resolve it. And one that I think both Mike and Chip suggested is the government actually aggressively trying to influence public opinion with regard to religion? Is this something like government proselytizing? And if it is, that would be some basis for rejecting it. An alternative framework is to ask just how preferential is the government system of adopting religious displays. And that's the issue that Michael McConnell confronted when he was a judge in the Sumim case, where a community says yes to one private organization that wants to place a Ten Commandments monument in a prominent location on public ground, and when another religious group comes forward and says, well, we would like to place our monument in a comparable location, a monument that reflects the tenets of our faith, the community says no. Now, I don't think that represents a violation of the free speech clause, because the government was, in a sense, taking over the message that was being communicated by the private group. But it certainly creates a significant Establishment Clause issue. Unless we're prepared to say that the government can pick and choose at its discretion which religions it will promote by accepting displays to be erected on government property, and which religions it will disfavor by forthrightly rejecting any displays that they offer, there has to be a preferentialism dimension to this analysis as well. There's probably other factors that would go into this, as well as the extent to which the government is trying to influence opinion towards or against a particular religion, and the degree of preferentialism that the government's policy suggests. But that's at least two themes that the courts could consider in trying to resolve these issues.
Okay, if people have questions, now would be a good time to line up. Yes, sir.
Thank you very much.